Law is a system of rules that are created and enforced through social or governmental institutions to regulate behavior. Law as a system helps regulate and ensure that a community show respect and equality amongst themselves. State-enforced laws can be made by a collective legislature or by a single legislator, resulting in statutes, by the executive through decrees and regulations, or established by judges through precedent, normally in common law jurisdictions. Private individuals can create legally binding contracts, including arbitration agreements that may elect to accept alternative arbitration to the normal court process. The formation of laws themselves may be influenced by a constitution, written or tacit, and the rights encoded therein. The law shapes politics, economics, history, and society in various ways and serves as a mediator of relations between people. A general distinction can be made between a. Civil law jurisdictions, in which a legislature or other central body codifies and consolidates their laws, and b. Common law systems, where judge-made precedent is accepted as binding law. Historically, religious laws played a significant role even in settling of secular matters, and is still used in some religious communities. Islamic Sharia law is the world's most widely used religious law, and is used as the primary legal system in some countries, such as Iran and Saudi Arabia. The adjudication of the law is generally divided into two main areas. Criminal law deals with conduct that is considered harmful to social order and in which the guilty party may be imprisoned or fined. Civil law, not to be confused with civil law jurisdictions above, deals with the resolution of lawsuits, disputes, between individuals or organizations. Law provides a source of scholarly inquiry into legal history, philosophy, economic analysis, and sociology. Law also raises important and complex issues concerning equality, fairness, and justice. Definition. Mainstream definitions. Numerous definitions of law have been put forward over the centuries. The Third New International Dictionary from Merriam-Webster defines law as, law is a binding custom or practice of a community, a rule or mode of conduct or action that is prescribed or formally recognized as binding by a supreme controlling authority or is made obligatory by a sanction, as an edict, decree, rescript, order, ordinance, statute, resolution, rule, judicial decision, or usage, made, recognized, or enforced by the controlling authority. The Dictionary of the History of Ideas published by Scribners in 1973 defined the concept of law accordingly as, a legal system is the most explicit, institutionalized, and complex mode of regulating human conduct. At the same time, it plays only one part in the congeries of rules which influence behavior, for social and moral rules of a less institutionalized kind are also of great importance. Whether it is possible or desirable to define law. There have been several attempts to produce a universally acceptable definition of law. In 1972, one source indicated that no such definition could be produced. McCobrey and White said that the question "what is law?" has no simple answer. Glanville Williams said that the meaning of the word law depends on the context in which that word is used. He said that, for example, early customary law and municipal law were contexts where the word law had two different and irreconcilable meanings. Thurman Arnold said that it is obvious that it is impossible to define the word law and that it is also equally obvious that the struggle to define that word should not ever be abandoned. It is possible to take the view that there is no need to define the word law, e.g. let's forget about generalities and get down to cases. History. The history of law links closely to the development of civilization. Ancient Egyptian law, dating as far back as 3000 BC, contained a civil code that was probably broken into 12 books. It was based on the concept of ma'at, characterized by tradition, rhetorical speech, social equality, and impartiality. By the 22nd century BC, the ancient Sumerian ruler Ur-Nammu had formulated the first law code, which consisted of casuistic statements, if, then. Around 1760 BC, King Hammurabi further developed Babylonian law, by codifying and inscribing it in stone. Hammurabi placed several copies of his law code throughout the kingdom of Babylon as stelae, for the entire public to see. This became known as the Codex Hammurabi. The most intact copy of these stelae was discovered in the 19th century by British Assyriologists, and has since been fully transliterated and translated into various languages, including English, Italian, German, and French. The Old Testament dates back to 1280 BC and takes the form of moral imperatives as recommendations for a good society. The small Greek city-state, ancient Athens, from about the 8th century BC was the first society to be based on broad inclusion of its citizenry, excluding women and the slave class. However, Athens had no legal science or single word for law, relying instead on the three-way distinction between divine law, themis, human decree, nomos, and custom, dk. Yet ancient Greek law contained major constitutional innovations in the development of democracy. Roman law was heavily influenced by Greek philosophy, but its detailed rules were developed by professional jurists and were highly sophisticated. Over the centuries between the rise and decline of the Roman Empire, law was adapted to cope with the changing social situations and underwent major codification under Theodosius II and Justinian I. Although codes were replaced by custom and case law during the Dark Ages, Roman law was rediscovered around the 11th century when medieval legal scholars began to research Roman codes and adapt their concepts. Latin legal maxims, called brochards, were compiled for guidance. In medieval England, royal courts developed a body of precedent which later became the common law. A Europe-wide law merchant was formed so that merchants could trade with common standards of practice rather than with the many splintered facets of local laws. The law merchant, a precursor to modern commercial law, emphasized the freedom to contract and alienability of property. As nationalism grew in the 18th and 19th centuries, the law merchant was incorporated into countries' local law under new civil codes. The Napoleonic and German codes became the most influential. In contrast to English common law, which consists of enormous tomes of case law, codes in small books are easy to export and easy for judges to apply. However, today there are signs that civil and common law are converging. EU law is codified in treaties, but develops through the precedent laid down by the European Court of Justice. Ancient India and China represent distinct traditions of law, and have historically had independent schools of legal theory and practice. The Arthashastra, probably compiled around 100 AD, although it contains older material, and the Manusmriti, c. 100–300 AD, were foundational treatises in India, and comprise texts considered authoritative legal guidance. Manu's central philosophy was tolerance and pluralism, and was cited across Southeast Asia. This Hindu tradition, along with Islamic law, was supplanted by the common law when India became part of the British Empire. Malaysia, Brunei, Singapore, and Hong Kong also adopted the common law. The Eastern Asia legal tradition reflects a unique blend of secular and religious influences. Japan was the first country to begin modernizing its legal system along Western lines, by importing bits of the French, but mostly the German civil code. This partly reflected Germany's status as a rising power in the late 19th century. Similarly, traditional Chinese law gave way to westernization towards the final years of the Qing dynasty in the form of 6 private law codes based mainly on the Japanese model of German law. Today Taiwanese law retains the closest affinity to the codifications from that period, because of the split between Chiang Kai-shek's nationalists, who fled there, and Mao Zedong's communists who won control of the mainland in 1949. The current legal infrastructure in the People's Republic of China was heavily influenced by Soviet socialist law, which essentially inflates administrative law at the expense of private law rights. Due to rapid industrialization, today China is undergoing a process of reform, at least in terms of economic, if not social and political, rights. A new contract code in 1999 represented a move away from administrative domination. Furthermore, after negotiations lasting 15 years, in 2001 China joined the World Trade Organization. Philosophy. The philosophy of law is commonly known as jurisprudence. Normative jurisprudence asks what should law be, while analytic jurisprudence asks what is law. John Austin's utilitarian answer was that law is commands, backed by threat of sanctions, from a sovereign, to whom people have a habit of obedience. Natural lawyers on the other side, such as Jean-Jacques Rousseau, argue that law reflects essentially moral and unchangeable laws of nature. The concept of natural law emerged in ancient Greek philosophy concurrently and in connection with the notion of justice, and re-entered the mainstream of Western culture through the writings of Thomas Aquinas, notably his treatise on law. Hugo Grotius, the founder of a purely rationalistic system of natural law, argued that law arises from both a social impulse as Aristotle had indicated and reason. Immanuel Kant believed a moral imperative requires laws be chosen as though they should hold as universal laws of nature. Jeremy Bentham and his student Austin, following David Hume, believed that this conflated the is and what ought to be problem. Bentham and Austin argued for law's positivism, that real law is entirely separate from morality. Kant was also criticized by Friedrich Nietzsche, who rejected the principle of equality, and believed that law emanates from the will to power, and cannot be labeled as moral or immoral. In 1934, the Austrian philosopher Hans Kelsen continued the positivist tradition in his book The Pure Theory of Law. Kelsen believed that although law is separate from morality, it is endowed with normativity, meaning we ought to obey it. While laws are positivist statements, e.g. the fine for reversing on a highway is €500, law tells us what we should do. Thus, each legal system can be hypothesized to have a basic norm, Grundnorm, instructing us to obey. Kelsen's major opponent, Carl Schmitt, rejected both positivism and the idea of the rule of law because he did not accept the primacy of abstract normative principles over concrete political positions and decisions. Therefore, Schmitt advocated a jurisprudence of the exception, state of emergency, which denied that legal norms could encompass all of political experience. Later in the 20th century, H.L.A. Hart attacked Austin for his simplifications and Kelsen for his fictions in the concept of law. Hart argued law is a system of rules, divided into primary, rules of conduct, and secondary ones, rules addressed to officials to administer primary rules. Secondary rules are further divided into rules of adjudication, to resolve legal disputes, rules of change, allowing laws to be varied, and the rule of recognition, allowing laws to be identified as valid. Two of Hart's students continued the debate. In his book Law's Empire, Ronald Dworkin attacked Hart and the positivists for their refusal to treat law as a moral issue. Dworkin argues that law is an interpretive concept, that requires judges to find the best fitting and most just solution to a legal dispute, given their constitutional traditions. Joseph Raz, on the other hand, defended the positivist outlook and criticized Hart's soft social thesis approach in the authority of law. Raz argues that law is authority, identifiable purely through social sources and without reference to moral reasoning. In his view, any categorization of rules beyond their role as authoritative instruments in mediation are best left to sociology, rather than jurisprudence. Positive law and non-positive law discussions. One definition is that law is a system of rules and guidelines which are enforced through social institutions to govern behavior. In the concept of law, Hart argued law is a system of rules. Austin said law was the command of a sovereign, backed by the threat of a sanction, Dworkin describes law as an interpretive concept to achieve justice in his text titled Law's Empire, and Raz argues law is an authority to mediate people's interests. Holmes said the prophecies of what the courts will do in fact, and nothing more pretentious, are what I mean by the law. In his treatise on law, Aquinas argues that law is a rational ordering of things which concern the common good that is promulgated by whoever is charged with the care of the community. This definition has both positivist and naturalist elements. Economic analysis. In the 18th century, Adam Smith presented a philosophical foundation for explaining the relationship between law and economics. The discipline arose partly out of a critique of trade unions and U.S. antitrust law. The most influential proponents, such as Richard Posner and Oliver Williamson and the so-called Chicago School of Economists and lawyers including Milton Friedman and Gary Becker, are generally advocates of deregulation and privatization, and are hostile to state regulation or what they see as restrictions on the operation of free markets. The most prominent economic analyst of law is 1991 Nobel Prize winner Ronald Coase, whose first major article, The Nature of the Firm, 1937, argued that the reason for the existence of firms, companies, partnerships, etc., is the existence of transaction costs. Rational individuals trade through bilateral contracts on open markets until the costs of transactions mean that using corporations to produce things is more cost-effective. His second major article, The Problem of Social Cost, 1960, argued that if we lived in a world without transaction costs, people would bargain with one another to create the same allocation of resources, regardless of the way a court might rule in property disputes. Coase used the example of a nuisance case named Sturgis v. Bridgman, where a noisy sweet maker and a quiet doctor were neighbors and went to court to see who should have to move. Coase said that regardless of whether the judge ruled that the sweet maker had to stop using his machinery, or that the doctor had to put up with it, they could strike a mutually beneficial bargain about who moves that reaches the same outcome of resource distribution. Only the existence of transaction costs may prevent this. So the law ought to preempt what would happen, and be guided by the most efficient solution. The idea is that law and regulation are not as important or effective at helping people as lawyers and government planners believe. Coase and others like him wanted a change of approach, to put the burden of proof for positive effects on a government that was intervening in the market, by analyzing the costs of action. Sociology. Sociology of law is a diverse field of study that examines the interaction of law with society and overlaps with jurisprudence, philosophy of law, social theory, and more specialized subjects such as criminology. The institutions of social construction, social norms, dispute processing and legal culture are key areas for inquiry in this knowledge field. Sociology of law is sometimes seen as a subdiscipline of sociology, but its ties to the academic discipline of law are equally strong, and it is best seen as a transdisciplinary and multidisciplinary study focused on the theorization and empirical study of legal practices and experiences as social phenomena. In the United States, the field is usually called law and society studies. In Europe, it is more often referred to as socio-legal studies. At first, jurists and legal philosophers were suspicious of sociology of law. Kelsen attacked one of its founders, Eugen Ehrlich, who sought to make clear the differences and connections between positive law, which lawyers learn and apply, and other forms of law or social norms that regulate everyday life, generally preventing conflicts from reaching barristers and courts. Contemporary research in sociology of law is much concerned with the way that law is developing outside discrete state jurisdictions, being produced through social interaction in many different kinds of social arenas, and acquiring a diversity of sources of, often competing or conflicting, authority in communal networks existing sometimes within nation-states but increasingly also transnationally. Around 1900, Max Weber defined his scientific approach to law, identifying the legal rational form as a type of domination, not attributable to personal authority but to the authority of abstract norms. Formal legal rationality was his term for the key characteristic of the kind of coherent and calculable law that was a precondition for modern political developments and the modern bureaucratic state. Weber saw this law as having developed in parallel with the growth of capitalism. Another leading sociologist, Émile Durkheim, wrote in his classic work The Division of Labor in Society that as society becomes more complex, the body of civil law concerned primarily with restitution and compensation grows at the expense of criminal laws and penal sanctions. Other notable early legal sociologists included Hugo Sinsheimer, Theodore Geiger, Georges Gurevich, and Leon Petrozaki in Europe, and William Graham Sumner in the U.S. Legal systems. In general, legal systems can be split between civil law and common law systems. The term civil law referring to a legal system should not be confused with civil law as a group of legal subjects distinct from criminal or public law. A third type of legal system accepted by some countries without separation of church and state is religious law, based on scriptures. The specific system that a country is ruled by is often determined by its history, connections with other countries, or its adherence to international standards. The sources that jurisdictions adopt as authoritatively binding are the defining features of any legal system. Yet classification is a matter of form rather than substance, since similar rules often prevail. Civil law. Civil law is the legal system used in most countries around the world today. In civil law, the sources recognized as authoritative are, primarily, legislation, especially codifications in constitutions or statutes passed by government and custom. Codifications date back millennia, with one early example being the Babylonian Codex Hammurabi. Modern civil law systems essentially derive from the legal practice of the 6th century Eastern Roman Empire, whose texts were rediscovered by late medieval Western Europe. Roman law in the days of the Roman Republic and Empire was heavily procedural, and lacked a professional legal class. Instead, a lay magistrate, iudex, was chosen to adjudicate. Decisions were not published in any systematic way, so any case law that developed was disguised and almost unrecognized. Each case was to be decided afresh from the laws of the state, which mirrors the theoretical unimportance of judges' decisions for future cases in civil law systems today. From 529–534 AD, the Byzantine Emperor Justinian I codified and consolidated Roman law up until that point, so that what remained was 1/20 of the mass of legal texts from before. This became known as the Corpus Juris Civilis. As one legal historian wrote, Justinian consciously looked back to the golden age of Roman law and aimed to restore it to the peak it had reached 3 centuries before. The Justinian Code remained in force in the East until the fall of the Byzantine Empire. Western Europe, meanwhile, relied on a mix of the Theodosian Code and Germanic customary law until the Justinian Code was rediscovered in the 11th century, and scholars at the University of Bologna used it to interpret their own laws. Civil law codifications based closely on Roman law, alongside some influences from religious law such as canon law, continued to spread throughout Europe until the Enlightenment. Then, in the 19th century, both France, with the Code Civil, and Germany, with the Bürgerliches Gesetzbuch, modernized their legal codes. Both these codes influenced heavily not only the law systems of the countries in continental Europe, e.g. Greece, but also the Japanese and Korean legal traditions. Today, countries that have civil law systems range from Russia and China to most of Central and Latin America. With the exception of Louisiana's Civil Code, the United States follows the common law system described below. Common law and equity. In common law legal systems, decisions by courts are explicitly acknowledged as law on equal footing with statutes adopted through the legislative process and with regulations issued by the executive branch. The doctrine of precedent, or stare decisis, Latin for to stand by decisions, means that decisions by higher courts bind lower courts, and future decisions of the same court, to assure that similar cases reach similar results. In contrast, in civil law systems, legislative statutes are typically more detailed, and judicial decisions are shorter and less detailed, because the judge or barrister is only writing to decide the single case, rather than to set out reasoning that will guide future courts. Common law originated from England and has been inherited by almost every country once tied to the British Empire, except Malta, Scotland, the U.S. state of Louisiana, and the Canadian province of Quebec. In medieval England, the Norman conquest, the law varied shire to shire, based on disparate tribal customs. The concept of a common law developed during the reign of Henry II during the late 12th century, when Henry appointed judges that had authority to create an institutionalized and unified system of law common to the country. The next major step in the evolution of the common law came when King John was forced by his barons to sign a document limiting his authority to pass laws. This Great Charter or Magna Carta of 1215 also required that the king's entourage of judges hold their courts and judgments at a certain place rather than dispensing autocratic justice in unpredictable places about the country. A concentrated and elite group of judges acquired a dominant role in lawmaking under this system, and compared to its European counterparts, the English judiciary became highly centralized. In 1297, for instance, while the highest court in France had 51 judges, the English Court of Common Pleas had 5. This powerful and tight-knit judiciary gave rise to a systematized process of developing common law. However, the system became overly systematized, overly rigid and inflexible. As a result, as time went on, increasing numbers of citizens petitioned the king to override the common law, and on the king's behalf the Lord Chancellor gave judgment to do what was equitable in a case. From the time of Sir Thomas More, the first lawyer to be appointed as Lord Chancellor, a systematic body of equity grew up alongside the rigid common law, and developed its own court of chancery. At first, equity was often criticized as erratic, that it varied according to the length of the chancellor's foot. Over time, courts of equity developed solid principles, especially under Lord Eldon. In the 19th century in England, and in 1937 in the US, the two systems were merged. In developing the common law, academic writings have always played an important part, both to collect overarching principles from dispersed case law, and to argue for change. William Blackstone, from around 1760, was the first scholar to collect, describe, and teach the common law. But merely in describing, scholars who sought explanations and underlying structures slowly changed the way the law actually worked. Religious law. Religious law is explicitly based on religious precepts. Examples include the Jewish halakha and Islamic Sharia, both of which translate as the path to follow, while Christian canon law also survives in some church communities. Often the implication of religion for law is unalterability, because the Word of God cannot be amended or legislated against by judges or governments. However, a thorough and detailed legal system generally requires human elaboration. For instance, the Quran has some law, and it acts as a source of further law through interpretation, qiyas, reasoning by analogy, ijma, consensus, and precedent. This is mainly contained in a body of law and jurisprudence known as Sharia and fiqh respectively. Another example is the Torah or Old Testament, in the Pentateuch or 5 books of Moses. This contains the basic code of Jewish law, which some Israeli communities choose to use. The Halakha is a code of Jewish law which summarizes some of the Talmud's interpretations. Nevertheless, Israeli law allows litigants to use religious laws only if they choose. Canon law is only in use by members of the Catholic Church, the Eastern Orthodox Church and the Anglican Communion. Sharia law. Until the 18th century, Sharia law was practiced throughout the Muslim world in a non-codified form, with the Ottoman Empire's Mesili Code in the 19th century being a first attempt at codifying elements of Sharia law. Since the mid-1940s, efforts have been made, in country after country, to bring Sharia law more into line with modern conditions and conceptions. In modern times, the legal systems of many Muslim countries draw upon both civil and common law traditions as well as Islamic law and custom. The constitutions of certain Muslim states, such as Egypt and Afghanistan, recognize Islam as the religion of the state, obliging legislature to adhere to Sharia. Saudi Arabia recognizes Quran as its constitution, and is governed on the basis of Islamic law. Iran has also witnessed a reiteration of Islamic law into its legal system after 1979. During the last few decades, one of the fundamental features of the movement of Islamic resurgence has been the call to restore the Sharia, which has generated a vast amount of literature and affected world politics. Legal institutions. The main institutions of law in industrialist countries are independent courts, representative parliaments, an accountable executive, the military and police, bureaucratic organization, the legal profession and civil society itself. John Locke, in his two treatises of government, and Baron de Montesquieu in The Spirit of the Laws, advocated for a separation of powers between the political, legislature and executive bodies. Their principle was that no person should be able to usurp all powers of the state, in contrast to the absolutist theory of Thomas Hobbes' Leviathan. Max Weber and others reshaped thinking on the extension of state. Modern military, policing and bureaucratic power over ordinary citizens' daily lives pose special problems for accountability that earlier writers such as Locke or Montesquieu could not have foreseen. The custom and practice of the legal profession is an important part of people's access to justice, whilst civil society is a term used to refer to the social institutions, communities, and partnerships that form law's political basis. Judiciary. A judiciary is a number of judges mediating disputes to determine outcome. Most countries have systems of appeal courts, answering up to a supreme legal authority. In the United States, this authority is the Supreme Court, in Australia, the High Court, in the UK, the Supreme Court, in Germany, the Bundesverfassungsgericht, and in France, the Cour de Cassation. For most European countries, the European Court of Justice in Luxembourg can overrule national law, when EU law is relevant. The European Court of Human Rights in Strasbourg allows citizens of the Council of Europe member states to bring cases relating to human rights issues before it. Some countries allow their highest judicial authority to overrule legislation they determine to be unconstitutional. For example, in Brown v. Board of Education, the United States Supreme Court nullified many state statutes that had established racially segregated schools, finding such statutes to be incompatible with the 14th Amendment to the United States Constitution. A judiciary is theoretically bound by the Constitution, just as all other government bodies are. In most countries, judges may only interpret the Constitution and all other laws. But in common law countries, where matters are not constitutional, the judiciary may also create law under the doctrine of precedent. The UK, Finland, and New Zealand assert the ideal of parliamentary sovereignty, whereby the unelected judiciary may not overturn law passed by a democratic legislature. In communist states, such as China, the courts are often regarded as parts of the executive, or subservient to the legislature. Governmental institutions and actors exert thus various forms of influence on the judiciary. In Muslim countries, courts often examine whether state laws adhere to the Sharia. The Supreme Constitutional Court of Egypt may invalidate such laws, and in Iran the Guardian Council ensures the compatibility of the legislation with the criteria of Islam. Legislature. Prominent examples of legislatures are the Houses of Parliament in London, the Congress in Washington, D.C., the Bundestag,
Please subscribe and thanks for watching.